Hi, welcome to the VeriDAO channel. I'm Lisa Davis, and today we are continuing our series on unpacking the amicus for the VeriDAO. Trey is going to be joining us, and today's topic is the argument. Be right back right after this. Trey, welcome to the VeriDAO channel. Things are moving right along in the SEC versus Ripple case, or I'm hearing more and more people call it the Ripple versus SEC case, the way things are going. I think we have some dates coming up. The replies were due on Monday the 5th, the responses, but I guess they're already in, and we'll go into those a little bit later. What do you think? Let's see, we got it. You sent me a great response by some of the community. Some of the feedback has been epic.
Yeah. The community is really responding to the actions that are going on in we'll call it the Ripple versus SEC case, because the reason that the community has flipped it on its head is because Ripple seems to be recording win after win after win. The SEC has been admonished by Judge Torres several times by stretching the law, and we'll go into specific examples in the argument case on our amici, which was filed, and it's probably the shortest portion of the document that we're going to go over, but it's the most important part, because Kenny Hertz-Perry did a very good job at building up the case and then making a gut punch at the very end, which we'll go over. But our goal here today is to highlight some of the community's reaction, give an update on where the case is, and then finalize with the Kenny Hertz-Perry finale and conclusion in the VeriDAO Amici.
Yeah, well, let's get some of that reaction from the community. Wade Teamer from Digital Hustle did a great short talking about some of the decisions and how these amici might be seen by the judges.
Love Wade.
It almost appears as if Ripple brought them in order to verify their case. The strength of VeriDAO entering the SEC versus Ripple case is that they're not associated with either party. However, they represent the exact same thing that's going on right now. So if the judge looks at the amicus brief from VeriDAO and determines that the SEC does not have the best history with dealing with digital assets, it's going to sway her decision. Okay. And then here's another thing. With these 12 amicus briefs now in play, this pushes this case back even further. Judges out.
So pretty strong statements there.
Yeah. Wade is right in this respect, Lisa. The VeriDAO represents Veritaseum token holders. Our goals and our aspirations as a DAO are several-fold, but one of the things that we do is we represent the best interest of Veritaseum token holders. And, I think that there's been a strong argument put out before this in our first two sessions about how the Veritaseum platform, Reggie Middleton, and the Veri token holders have been maligned, have been attacked with malicious intent by the government. And Teamer's exactly right. What happened to the Veritaseum token holders is a solid real life example of what could happen to the XRP token holders if the judge doesn't take our amici into consideration when weighing the decision in the Ripple v. SEC case.
It absolutely does. I mean, it's such a parallel of, what we, the people, are facing from the people that are supposed to actually be looking out for us. Do you want to get into our document, the amicus?
Sure.
Okay, we can go right into that. Like we said, we're on the home stretch. We're seeing we're in the third portion of this document and to the argument. And it goes in to really parallel the arguments that Ripple has in its motion for summary judgment. So it says, as noted in the preceding section, VeriDAO endorses and agrees with the arguments furthered by Ripple in its motion for summary judgment and by the Digital Chamber of Commerce and Blockchain Association regarding secondary holders. Furthermore, as stated above, like XRP, the Veri token should not be considered an investment contract. An investment contract is a contract, transaction, or scheme whereby a person invests his money in a common enterprise and is led to expect profits solely from the efforts of the promoter or a third party. And then SEC, Howie, blah, blah, blah.
Well, I think it's important to note here, let's break down what an investment contract is. You know, the gold standard for kind of determining what an investment contract is was litigated under the Howie versus SEC case way back when. I don't exactly remember when the case was adjudicated, but basically what the Howie test says is that there has to be an investment of money, and I'm just taking this off the top of my head. There has to be an investment of money. There has to be a common enterprise. There has to be an expectation of return, and there has to be an investment contract. So an investment contract basically is a contract between two parties, two entities that require signatory on both sides, with the expectation of the investor realizing a return for the efforts of the entity that is on the other side of the contract. So I think it's really smart that the Ripple attorneys went into the investment contract side of this, because I don't think that the SEC can produce an investment contract between XRP token holders and Ripple Labs. As well, you know, the Veritaseum token holders had to sign a notice and terms and agreement conditions stating that we understood that we were not entering into a contract with Veritaseum, that we were purchasing prepaid services for software, much like you would do a Microsoft subscription. So, you know, our friend Nick Morgan over at ICAN, Investors Choice Network, who we did a really interesting discussion with. If the viewers here haven't reviewed or seen that video, go back to the VeriDAO channel and watch that video. Reggie Middleton joined us, and we kind of got into a very interesting discussion about his amici brief. But basically, in his amici brief, he goes into great detail about what an investment contract is. And do you have that where can you pull that up real quick?
The ICAN? Sure.
Yeah, let's go ahead and pull up the ICAN. Let me see if I can pull it up here real quick as well. So I thought I had it pulled up. So that was an investment.
I do have my tab. Here it is. Amicus. ICAN. Here we go. This is, and we wanted to talk about in this part 2, the SEC relying on a vague term to regulate digital assets.
Right. We want to focus in on that. Can you read what Nick identified in the 1933 Securities Act as the specific securities that the SEC has authority to regulate? I think it's that middle part right there.
Okay. The term security means any note, stock, treasury stock, security, future, security-based swap, bond, debenture, evidence of indebtedness, security, certificate of interest, or participation in any profit-sharing agreement, collateral trust certificate, pre-organization certificate or subscription, transferable share, investment contract, voting trust certificate, certificate of deposit for a security, fractional undivided interest in oil, gas, or other mineral rights, any put, call, straddle option, or privilege on any security, certificate of deposit or group or index of securities, including any interest therein based on the value thereof, or any put, call, straddle option, or privilege entered into on a national securities exchange relating to foreign currency or in general, any interest or instrument commonly known as a security or any certificate of interest or participation in temporary or interim certificate for, receipt for, guarantee of, or warrant or right to subscribe or purchase or any of the foregoing.
So to summarize, there's a very specific long list of things that the government considers a security. I don't see anywhere in there where it says digital asset. I don't see anywhere in there where it says XRP token. I don't see anywhere in there where it says Berry token. So what the SEC has done is they've taken the term investment contract and really kind of stretched that out to cover a big umbrella of everything that the SEC deems a security and under the digital asset, the brand new digital asset space. So they can't provide a contract that is signed by two entities, and they're specifically kind of focusing narrowly in on this investment contract space. So our attorneys took the investment contract idea, and they said further in the statement, they said, unlike Howey and its progeny, the purchase of Veri tokens, one, does not involve a contract between a promoter and investor, and two, said that there is no obligation to do any post sale by the very central persons, which is Reggie Middleton, all the Veritaseum entities, and three, that we have no right to share in profits earned by the very central persons. So, you know, right off the bat, the SEC's argument that we're operating under the terms of an investment contract are shot down by two tenets of the Howey position and one of the 1933 Securities Act.
It seems pretty clear, and it does parallel both arguments, or both amicus, or our amicus in their summary. I'm sorry.
Yeah. And you know, there's a lot of people in the community who are saying right now, well, you know, we've got all these amici that have been filed. You know, how much sway is that going to have over Judge Torres, Judge Netburn? How much of an impact are those amici going to have on the final decision? And you know, as Wade said at the very beginning, the VeriDAO is the only one that has kind of a future-looking evidence of what's going to happen to secondary market participants. But you know, we've obviously gotten under their skin. We've gotten under the skin of the SEC. We got them to take notice, and you can find evidence of that when you go to. Yeah, that's really funny. There's
They've
actually
been watching our
tweet.
videos. Yeah,
They've been watching our videos. I almost guarantee they're watching the VeriDAO videos. And there was a guy that put out a tweet. What was his name? It was Rossi. Let me see.
Fred Rispoli.
Fred Rispoli. It's hilarious. Yeah, it's
so
hilarious.
He says, congrats to all amici in the SEC versus Ripple saga. The SEC's reply is about to drop publicly, and it is very clear that the amici got in its head. Deaton, Tapjets, JSpin, The Reaper, VeriDAO, Ball Hill, Coinbase, Paradigm, Digital Chamber, Cryptilian, InvestReady, whatever. So he tags everybody. Pretty cool.
Yeah, so it's really interesting that people that are watching this case closely, that have read all of the documents. I've read most all of the documents. It's obvious that you know, that the community has gone against the SEC and in favor of Ripple Labs. Now, it's really, really unusual for a case where the SEC is accusing an entity of committing fraud, like they did Reggie Middleton and Ripple Labs, where the whole community goes against them. And I think that our attorney in Florida, Jeremy Hogan, actually posted a tweet which a lot of people will have something to relate to, especially it being football season here in the U.S. Go ahead and read that for the audience. I think it's
classic.
Hilarious.
Accredify failed its amicus brief on behalf of the SEC by the deadline last night. So that leaves the final tally at 14 for Ripple and 1 for the SEC. for you Americans, Ripple scored 2 touchdowns and the SEC got a 1-point safety.
So
So that's the update.
at the end of the day, Jeremy Hogan puts a frame of reference around it so that all the American football fans can understand it. We actually won the Amici Bowl 14-1.
With that gold standard just waiting for us at the finish line, I think.
Right. So going back to the plaintiff's reply, I think it's really important to highlight the plaintiff's reply as evidence that we're kind of getting under the skin of the SEC. They spent a whole section talking about the amici. And it says it's under the section, I think it's 3B, the defendants and amici premise their arguments on laches and estoppel defense that fails as a matter of law. When you read through this, it kind of defies logic because, either the that's exactly it. Either the SEC attorneys completely failed their law school studies, and in their practice of law in the past, however many years they've been practicing, they failed to go back and kind of brush up on the law, or they're blatantly abusing their interpretation of the law to fit the narrative that they've created. So they state defendants know that any claim about the supposed vagueness of investment contracts, they put it in quotations, is doomed from the inception. They accordingly attempt to refashion their defense premise on the idea that the time the SEC took to investigate the case created uncertainty and confusion. Well, they had since 2013 to kind of look at it and determine if it was a problem. So the whole SEC's case is looking back on when Ripple first started offering XRP tokens for sale to 2020, which is a 7-year period. I don't know that any government agency that takes that long to ascertain on whether they want to go after money or not, or whether they want to regulate an entity or not. So that's kind of stretching it right off of the bat. The implication of this argument is that the Constitution requires the government to preemptively reach a conclusion about the legality of a person's conduct before it can gather all the facts. Well, I mean, if you need 7 years to gather all the facts, you either don't have the right resources or you're being vague on purpose so that you can gut punch an industry at the end of the day. And I think that's actually where they're going.
Yeah, that's like having a police officer just ride with somebody. Well, they're just going to ride with you nonstop because you might for 7 years, just in case you speed.
Exactly. Exactly. I mean, it's like having
really
a constant,
insane.
It's kind of like having a constant surveillance state on every aspect of your life. And I think the Bill of Rights has something that they might say that the government is not able to do that. But anyway, they go on to say that, they took their time and that's no legal defense. They go on to say that there are specific limitations with which the defendants cannot shorten under the guise of fair notice. So they go into the fair notice claim. If you'll scroll up, they go into the fair notice claim a little bit there. And then this is where I think it becomes really interesting. It says defendants suggest and various amici also argue, and I think that they're specifically honing in on some of the language that we used in our amici. The VeriDAO did, Kenny Hertz Perry did, to argue that the SEC's approach to digital assets has been regulation by enforcement. Now we talked about regulation by enforcement.
This is a little further down. I think
it's a little further down.
Here it is.
It's on page
the
30,
complaint
32.
Regulation of enforcement. Okay. Yeah.
Yeah. So they hone in on the approach to digital assets has been regulation by enforcement. Now here's the key, which itself sustains a fair notice defense. Some amici claim that the SEC must issue rules in this space before enforcing the law. But listen, we're not saying that there's some codified law on the books that says that the SEC can't regulate by enforcement. What we're saying is that there is no regulatory authority. There is no codified law. There is no prior court cases which say that the SEC can move in and regulate the digital asset space. And instead, what they've done, they've been purposefully vague about their
Mhm.
actions because they want to reach out and have as much power as possible, and they want to cut out a big piece of the pie for themselves. To be able to enforce for their friends and collect monies for their friends. To my recollection, the EOS settlement was $20 million. Ripple has spent near $80 to $100 million
Mhm.
defending itself. They took, I think, $9.5 million from Reggie, which included 40,000, almost 40,000 Ethereum tokens, which I think at this point would be a very big number, $50 million maybe.
Wow.
And, you know, they said, well, we're going to give that money back to the community through the Very Fair Fund. Well, to this date, 3 years later, nobody's collected a red cent of that Very Fair
Mhm.
Fund, and less than 1% of the people in the Veritaseum community even filed for it. So it's, you know, just another piece of evidence that shows that the Veritaseum community is on the side of Reggie Middleton against the SEC when the SEC is supposed to be protecting us. So,
Absolutely.
you know, I don't know
Well,
what
and
kind of
back to this, their reply, the plaintiff reply, where they talk about while they complain of regulation through enforcement, maybe pithy soundbite or even recurring policy dispute, it's not a valid legal defense. And to your point, no one was saying that was a legal defense.
nope.
Are they trying to distract or mislead the court with this statement instead
I
of?
think that Judge Torres is way too smart to be distracted by this
Sure.
nonsense. You know, regulation by enforcement simply means that the SEC is picking on small projects that with very little funds in the coffers to defend itself. You
Ability
know,
to defend itself. Yeah.
they picked on Kick, they picked on
Library.
Veritaseum, they picked on Library. They've
Hmm.
almost ruined Library. I think Library is
Yeah.
going bankrupt because of it. You know, they took 99% of Reggie Middleton's assets. So they pick on all of these smaller entities, and that's what I mean by regulation by enforcement. There, you know, you can't go to a law and say the SEC can't do this because there's no law against regulation by enforcement. But it's obvious in real time that these projects, which I think the SEC picked on because they wanted to collect a number of wins in their pocket to
Hmm.
show the government how great they were and how much they were defending, you know, the space and defending retail. Well, if they were defending retail so much, why the hell
Why are
didn't
there?
they regulate FTX? They had Sam
Right.
Bankman-Fried in their offices doing consults with Gary Gensler, but he didn't see that one coming. But he damn
Mm-mm.
sure put Veritaseum in the toilet with their regulation.
And why are there 14 amici that are saying the SEC harmed us? I mean, and why are we having token holders in our amici specifically? We are token holders in the secondary market that are saying we were harmed by the SEC, not by Reggie Middleton.
That's right.
And that's
The people have
where
spoken. The
that really
people have
hits the
spoken.
road
We, the
for
people,
me.
have spoken, and we do not trust the SEC.
Mhm.
If we trusted the SEC, that score would have been flipped. There would have been 14 points for the SEC and 1 for Ripple Labs. But
Yeah, can you
instead, the
imagine
people
if
have
they
spoken.
spent the 7 years that they went after Ripple Labs and after Reggie, just looking into Sam Bankman-Fried and FTX and, you know, when Maxine Waters is blowing him kisses in Congress or whatever, you know? I mean, maybe they should look into that a little bit. It's
Maybe
just
they have some
incredible.
bigger fish to fry. Maybe there's some fraud being perpetrated on the people by entities that have given money to both Republicans and Democrats.
Mhm.
You know, there was Mario Nawal put up a big Twitter space here recently where he had Kim.com and he had Rand from South Africa on there, who runs a big YouTube channel on cryptocurrencies.
Mm.
And he had some very, very sophisticated cryptocurrency people who knew what they were doing, knows how centralized exchanges that operate on leverage, knows how they work. And Sam Bankman-Fried came on and was being grilled by this panel of people. And it was very obvious after a few questions were asked of Sam Bankman-Fried, and he admitted to this in public, that he committed fraud to the tune of about $16 billion. So Gary Gensler and the SEC is not worried about this obvious Ponzi scheme that ruined people's lives, but they're going to go after Library and Veritaseum and Kick. I don't get it.
Because those are market disruptors of the old legacy systems of the, the buddies. I mean,
Yeah.
follow the money,
Yep.
And you can look at Gary Gensler's own words when he was teaching at MIT, saying that, they have mechanisms in place to stop market disruptors. And if you have a business that you want to bring to market, you have to give them, I can't remember what he said, 30 to 50% of your company, or create a token, I believe is what he said.
I saw that. He was teaching MIT students.
He was teaching MIT students and telling them how if you want to play, you got to pay to play.
Now, I get what you're saying, because when Reggie Middleton first came out and had that interview back in, gosh, I want to say it was 2015 or so, with Max Kaiser, and they were on this, I think they were on CNBC, and Max was running a show, and he invited Reggie in, and Reggie said, here's my idea. And he brought out his wallet, and he described the Veritaseum platform and how it was going to disintermediate that middleman, that rent seeker who had no value to a project. He was going to cut that out through the Veritaseum platform and give that 30 to 50% back to the inventor and back to the innovators who were piling on top of that invention, and back to the people that invested in it. Can you imagine if 30 to 50% of a great idea was split, and the inventor got to invent more and the investors got to keep more of that capital? How much better this world would be. But absolutely. I think you're right in this respect. And Gary Gensler is working off of the old banking model, and he's teaching the future leaders of the crypto space, or the MIT guys that he considers the future leaders of the crypto space, that we're going to do the old boss same as the new boss, and we're going to get our cut.
And if you don't like it, then you end up, then it moves innovation outside of the US. And that's where we're going to have this giant mind suck out of the US. All the brilliant minds,
call it the brain drain.
Brain drain. Yes. Sorry, I was calling it mind suck. I knew I'd heard the term before. But the brain drain out of the US, all the great ideas, the innovators, and then the jobs with it. And the brilliant minds and their families. And then guess what? They go and have babies and families and build legacies outside of the US. And all of a sudden, America's not great ever again. If we can't build opportunities here for families and innovation.
Yep. We're definitely ceding our position as innovative leaders of the world, as the manufacturing leaders of the world. And I think that everybody that is really kind of keeping a sharp eye on the crypto space knows for sure that the future is in cryptocurrency. Whether the government's going to control it or it's going to be a private label cryptocurrency, I think that battle is yet to be determined. But the space, our financial system transition is definitely going to be in the digital space. It's not going to be in the legacy space.
Yeah, I think that's just it. It currently is in the digital space. They just don't tell people that. I mean, right now there's not paper dollars at your bank. If you went down there and tried to pull out,
there's very few. I actually went to my bank and tried to pull out some money the other day, and they said, "Oh, we can only pull out X amount of money." And I said, "Really? Why is that?"
Yeah.
And then, the teller kind of looked at me sideways. She's not used to people asking her why.
The questions. Yeah. You're not supposed to ask. You're just supposed to
I think it's getting serious out there. I think that the banks, the legacy banks, are in trouble. I think that the interesting thing about CBDCs, and this is kind of a tangent, but I've got to say this. The interesting thing about CBDCs is the Fed is going to be going directly to the consumer with CBDCs. So the banks are kind of left out of that whole equation. So if I was Jamie Dimon at JP Morgan or some other banks, I would be seriously concerned about how the Fed is moving forward with these CBDCs.
Yeah, it does really put the banks in an opportunity for a new role of really
I think
what they
I think
used
the
to do
banks are going
is
to be
serve
obsolete.
the communities, you know.
Yeah, I think they're
They're
going to
they're
be
gonna have be
obsolete.
forced to. Yeah,
Yeah,
they
they're going to be
could.
forced out. And
Yeah.
that's I think that's by design. So
Mm,
we'll see how all that plays out. You know, the very Dow did a big deep dive into JP Morgan coin, and I think the smart banks like JP Morgan have been developing methods, systems. I mean, gosh, HSBC, Wells Fargo, JP Morgan. Um, I think the NASDAQ Stock Exchange, all of these financial entities have cited Reggie Middleton's patent.
mm.
So they've been working on this for a long time. Reggie was there first. He patented it first. They're all mad at him now that he patented it first. But you know what? That's how business works. Those that are first to the finish get the rewards. And I think that Reggie's system eventually, whether it's the governments that are going to take the lead, I think they'll be rejected, but I think they'll take the lead,
Yeah.
then be rejected, and then the private companies like JP Morgan and Wells Fargo will come forward and say, "Oh, we've got a system that works for the people," but they're going to have to pay Reggie his due.
It's going to be interesting to see it all play out. I also was thinking about how COPA has really just mistreated the whole open source community.
Yeah, it's
They've
such a
really
joke.
misled them. Yeah, you
Such a
can
joke.
still choose to give away or have something, a creation. As an innovator, you can have something, you created it, you want to give that thing away, live in a utopian society. That's great. Make sure that you protect your IP so that you can continue to make those decisions, because COPA has them signing away their rights to be part of this organization and saying like, well, if you come into COPA with your open source code, then basically you're giving away your opportunity to be able to sue if somebody copies it or takes it from
Yeah.
you
Here's
or
the here's
infringes on it. Which I'm like, why would they even put that in the rules? Why is that not a red flag to people? Um,
Yeah, well, people
and
don't.
they're going to buddy with Wall Street, and the big lawyers are
Yeah,
coming with
yeah.
their.
Yeah, when the big boys move in, what COPA is trying to do, and COPA is an organization composed of Coinbase and Kraken and Circle, which is Jack Jack from Twitter, Jack Dorsey, I think.
Mhm.
Anyway, it's a big conglomeration of people that are in the crypto space that know what's coming as far as the digital asset space it means for the world and our financial systems. And what they've said is, even though a bunch of them already have patents filed on certain aspects of cryptocurrency, they've all said, well, if you have intellectual property, you really shouldn't enforce it on the rest of us. Which is, come on, man, that's just stupid.
It is really stupid because they're not doing that. And
No.
that's where like everybody's really excited about Elon right now and Twitter and all that, but he's also talking about, Telegram is now coming out with a wallet.
Yep.
Elon, which people are forgetting, he already has I think it's called Stripe that you can use, or Strike, something like that. There's already a cryptocurrency payment method
Yep.
available through Twitter, and he was talking more and more about that. I think that could end up being a little devil's
Well,
advocate kind of
Elon's
dangerous
goal
thing.
is to create the universal app, the everything app. He wants to now that he's got the media side of it. He's been in love with the Doge token for a long time. I think he's
Hmm.
the undisputed CEO of Doge. But he's got a deep reach into the cryptocurrency space. I think he's going to be competing with YouTube by expanding the video and technical aspects of Twitter. He is going to have whether it's the uh, Elon app or he uses the Twitter brand, the Twitter app. You're going to be able to download social media content, use payment systems within Twitter, communicate, pay your taxes. I think he
So if
wants
he ends
to.
up fighting with Apple, and people were talking about he might come up with his own phone, he might wait and do it there.
He's
on
waiting to
his own
see. He's
phone
waiting to see if
where
the
that's going to flush
contestants
out.
in the battle duke it out, injure one another, who comes out on top, and I think then he's going to attack that entity. So I think
I
he's going
see.
to be he's smart. You know, he's read some of the you know,
Art of War.
Art of War and
Mhm.
how to maybe he's even read you know, How to Do Negotiations by Trump. What was that book that he put out?
I think I have it up there somewhere.
Anyway, Elon's a pretty
I'd have to
smart
look
dude.
for
I
it.
think that he's
Yeah.
kind of biding his time before he jumps in and makes his move. But you know, and which is smart because you know Elon's letting the rest of us fight the battles with the SEC and letting the Copas of the world come up and kind
Hmm.
of duke it out with Reggie Middleton's. You know, and the smart thing about the Veritaseum IP, the intellectual property that Reggie owns, which I think is probably one of the most, if not the most valuable piece of property in the world today, is that no matter who comes out on top, whether it's the CBDCs and the federal government, whether it's Elon Musk, whether it's Ripple, whether it's the Lightning networks, whether it's Uniswap, he gets a piece of the action.
Hmm.
You know, and you know, we're in it. The VeriDAO is in it to fight the good fight here in the trenches, and bring some kind of refreshing insight to the Ripple versus SEC case where we can, because you know, like I said before in the last installment of the Breaking Down the Amici from the VeriDAO, we're going to look back on our efforts years from now, you know, maybe when we have our grandchildren by the fireplace in a warm Christmas setting, we're going to look back and say, listen, we didn't sit by idly and let things happen. We got involved. We jumped in the
Hmm.
fight. We were battling to the end. We had a voice and our voice was heard. So I think that's the important thing about what the VeriDAO is doing is, you know, we're getting in there and fighting that fight. We're doing the punches, and at the end of the day, I think that we are going to make a significant impact on how the Ripple versus SEC case comes out, because you know, I think there are some good judges out there. I think there are
Hmm.
some good politicians out there. I know that's a hard to believe for most of us, but there are some good people out there that still work every day to adhere to their oath of office and are interested in we the people.
Yeah, we can't give up on justice and our Constitution,
No.
our constitutional rights, and the courts. I mean, I still believe in truth. I won't give up on truth, and so I'm really honored to be able to, be a part of this and have our voice heard. And it really is the voice of we the people, and that's where I
Yep.
feel so strong about the VeriDAO amicus and being able to bring that voice to the judges and them hear, hey, warning, this is real time experience of what happens to token holders in the secondary market when we're asking for guidance. We're reaching out, we're going through the channels that are appropriate, we're
Right.
doing all the things, and instead we are admonished by the SEC. Instead, we're threatened
Yeah.
by them, and then they are obviously paying attention to every little thing we're saying because they're
Yeah.
mentioning our words in their own response and reply. So,
Yep. Yep. We've gotten under their skin because they know they're losing. You know, it's kind of like when you have it's when you have like a splinter in your finger and it's just irritating you all day and you can't get it out and you can't get it out. And then you put your hand down and somebody slams something on your
yeah.
finger and it hurts even worse. I kind of
Yes.
look at that as maybe what we're doing to the SEC right now. But you know, the truth is that there's millions and millions of us, billions of us, if you look at a worldwide perspective, and only a few of them.
Yeah.
And I think that if we are the microphone for the people's voice, then eventually we'll be heard by good people like Judge Netburn and Judge Torres.
Hmm.
So let's move on. I think that the
Yeah.
best part of the Amici here is to follow in the conclusion.
Okay.
So if we go back
Let
to
me.
our Amici and continue to
Yep.
break it down here, on page 8,
Yes.
it
Okay.
says, moreover, to the extent that the SEC does extend its theory beyond the sales of the issuer and its affiliates, the court should reject such broad applications. Section 4A1, this is the Section 4A1 cutout of the 1933 Securities Act, exempts the application of Section 5 of the Act, which specifically governs the prohibition and sale of unregistered securities from transactions by any person other than the issuer, underwriter, or dealer. So it's at this point that I'm going to tell you that the VeriDAO is working on some very important things beyond legal cases like the amici and trying to get a no action letter from the SEC. We are deep in conversations with entities about what we can do with the Veri token and how we can utilize the Veri token in the future to accomplish goals that we set back in 2016 when we first got involved in the project. And so there's certain things that you have to do when you set out to get involved in a transformative disintermediating technology like Veritaseum. First of all, you have to have the technology. Check that box. Second of all, you have to make sure that you're in a legal position which protects your efforts on a forward-going basis. This is where we check that box, because under the 1933 Security Act cutout, Section 4A1 of the Act, it says that unless we are a issuer, which we're not, Reggie Middleton's the issuer, an underwriter, which we're not, or a dealer, they cannot come at us and regulate us as if we were one of those three entities. And it goes on to say, furthermore, Rule 144 provides a safe harbor from the fact in intensive definition of underwriter, excluding from underwriter status any person who meets its 5 conditions. And that was the SEC exchange versus Genovese case. So what the SEC is doing in the Ripple case is they're saying, well, listen, the Ripple Labs is an entity who's profited by issuing XRP tokens, and therefore there's a common enterprise. But what the SEC does not explain in the law is how every XRP token holder benefits from the negotiations and contracts that the Ripple Labs has with their clients. So it says, thus, if the SEC's position truly extends to every single buyer and seller of XRP, like the Veri token in the secondary position, this position conflicts with the limitations of the Act, which is the 1933 Securities Act, and supporting rules. The court should not enter any ruling to that effect. So basically what Kenny Hertz Perry is saying here is that there's laws which govern what the SEC can do and what they cannot do. And nowhere in between should they step in and think that they can overrule and walk on and regulate people that are non-issuers, non-dealers, and non-underwriters.
Right. It literally says those 3 things, and then it literally says the rule provides a safe harbor. So we're sitting in our safe harbor, SEC.
We are sitting in the safe harbor. So SEC prosecutors, SEC enforcement arm, Gary Gensler, when you hear this part, go back and look at the law, because the law protects us. So we're working on some interesting things that we have the technology for. We have the legal foundation set that we can stand on and move forward in. And the other part of it is market timing. We have to have the right market timing for what we're planning on releasing to the community to have a impact which benefits the world. And what we're going to do, I think, is going to be legally sound. It's going to have the technology behind it, and it's going to rekindle the original intent of the Veritaseum token under several of the Veritaseum platforms, but specifically the VE rents.
That's exciting. I mean,
It's really
just
exciting.
to think that there could be that kind of free capital markets, equal opportunity for people to come in, just really is a game changer for humanity.
It is. And our attorneys kind of gave a hint as to how we're going to accomplish the legal foundation. I think it's on page 9 of the Amici brief. It says, furthermore, if digital assets like XRP and the Veri token were generally treated as commodities, and subject to the purview of the Commodities Future Trading Commission, CFTC, as mentioned by several of the referenced pieces of legislation in the Amicus Curiae brief of Philip Goldstein and our friend Nick Morgan at Investors Choice Advocates Network, downstream holders of the digital assets would have a greater confidence they could engage in the trade of their digital assets without fear of engaging in a sale subject to rescission and penalties due to registration issues. In other words, there may be more than one regulatory body that we can count on to work with the VeriDAO to accomplish our goals.
Mm-hmm. Very interesting. I'm curious what the guidelines are there,
So basically, we've got a legal opinion that says maybe we can move forward with a different regulatory body and accomplish their goals, which I think should be very exciting for the Veritaseum community. They may have tried to wound us, they may have attacked us unfairly, but they have not killed us. In fact, I think they have made us stronger.
Well, knowledge will do that to you.
Yeah, exactly. And so our attorneys made a rock solid case for us to stand on to not only support the Ripple and their motion for summary judgment, but also to tell the Veritaseum story. And really, the third leg of that stool, if you really take this document and kind of break it apart, is a pathway, a roadmap forward for Veritaseum token holders to make a difference in this world. And I think that's really why the VeriDAO came together in the first place. It may seem like a grand statement, but I think that we are in the middle of a transformation which is going to be beneficial to the people and not the elite.
It's a bright future for all of us. I think that there's so many moving parts happening right now, and it seems to be all about the currency. And I think it's really interesting or very telling that that the SEC even brought up Constitution, the Constitution in their response.
Yeah, and their retort. Yeah. They want to make it seem like they're holding on to the Constitution as some guideline. I think that they've trampled on the Constitution,
I think so too.
like a cow at a rodeo.
Yeah, I just think, it's really wild. Our conclusion statement, I think, is really powerful, short and sweet and to the point. But for all foregoing reasons, the court should grant Ripple's motion for summary judgment and deny the SEC's cross motion for summary judgment. The court should also avoid any rulings that endorse an extension of the prohibitions of unregistered sales beyond the clear and limited dictates of the act.
So yeah, that's a powerful statement. So our attorneys are letting Judge Netburn and Judge Torres know that there is a body of law which the SEC has to adhere to in order to fit into the confines of being a regulatory body. People mistakenly think that laws are all to regulate the people. The original intent of the Constitution was for the government to have limits on their ability to trample on the God-given rights of the people. And basically what our attorneys have done here is say, listen, the people have rights and they will not be denied.
That's right. And Congress should be doing their job in this. You know,
Yeah,
that's the other
they've
thing. They've really
kind
let
of let
us
us down.
down. They've been dragging their feet, and this whole thing has been done backwards, and it's hurt the people. And
Yep.
this is the cost of it, you know. And now
Yep.
they have to face the music. It's being brought into the light, and we're going to all go through it, and there's going to be accountability for it. Did we want to go pull up Ripple's reply and go through any of that?
I just think that there's the Ripple's reply was so weak. It was such an amateur hour document that it's almost not worth noting.
Or you
You know,
mean SECs?
Oh, I mean SECs. I'm sorry.
Yes.
Ripples. Yeah, it's easy to get confused when you're reading this many
Sorry.
documents
Yeah.
and trying to put your
Guys.
thoughts together with it. But yeah, let's bring up. Let's see. That would
The
be the plaintiff's
defendants.
reply. That would be the defendant's reply. Yeah, good idea.
Yeah,
Good
because
idea.
we got into the plaintiffs a little bit, but we've had enough of that.
Yeah, so I think that as I was going into tearing up the SEC's final statement, you know, even the Ripple attorneys are kind of saying, they're trying to be nice, but they're saying, listen, they've stretched things beyond comprehension here. And I think they say it right in their preliminary statement when they say the SEC's opposition brief confirms that the defendant's motion for summary judgment should be granted. So, in other words, our opponent here has made our argument for us. The SEC cannot show that any offer of a sale of XRP, much less everyone from 2013 to 20, as it alleges and bears the burden to demonstrate, was an offer or sale of an investment contract and therefore a security under the federal securities laws. I think we can probably, we don't need to go into the several pages of the reply. I think there's 65 pages in total.
Okay.
Maybe 55 pages of contract law that they've gone into. But you know, basically when you look at the Howey case, the gold standard of what an investment contract is, basically the Howey contract, the Howey case was about I think it was orange orchards in southern Florida.
Yes. Yeah.
And basically what the what the XRP attorneys, the Ripple attorneys are saying is, listen, just because you buy an orange at the store doesn't mean that you're supporting and have an investment contract with all of the orchards in Florida.
Right.
And
An orange itself is not an investment contract.
Or not a security. Is not a security. Exactly right. And so, you know, if you kind of break it down to its lowest common denominator, you know, we're 100% in the right. And we are the VeriDAO is 100% in the right by supporting the Ripple statements, and the Ripple lawyers are 100% right against the SEC, saying, "Hey, look, you got this all wrong. You know, you're comparing things that don't equate."
Yeah, it's a really strong argument. I don't think they even need that many pages to go into it, but I'm sure they're doing a great job in all their explanation. And I'm sure the judges are able to see that clearly as well.
I think that the case is going to be, I don't think it's going to go to trial. I'm going to make a prediction. I don't think it's going to go to trial. I think that there is such strong sentiment from we the people against the SEC. There is such a cohesive argument and set of case law that's been put in front of the judge. I don't see how she can put her scales up and weigh out the body of evidence that's been presented to her and come to a conclusion that the SEC is right. They've stretched the definition of an investment contract. They have not made any connection between the body of case law that exists, and you know, they've proved themselves to be inept. And the SEC, I think, is an entity that is in peril of embarrassing itself on a national stage in this case.
Absolutely. And just in the worst way,
Yeah.
worst way of harming the people that you claim to be protecting and defending.
Yeah, their motto, the first statement they make in their motto is to protect the retail investor, and in my book, they've failed 1000%.
And they should be held accountable for that, you know.
Well, that's to be
So
determined, but I think in this case,
that's
we're going
what
to see a
happens.
victory for Ripple Labs, of which is a victory for all of those of us who have been adversely affected and harmed by the SEC. It's a victory for Ripple Labs. It's a victory for Veritaseum. It's a victory for Library, praying that they can stay
Yeah.
solvent. So it's a victory for crypto in general as we move forward and try to impact the world for the betterment of every human being.
Definitely. Well, thank you so much for helping me unpack this. You guys, if you're interested in watching, we've got parts 1, 2, and 3. You can go to the VeriDAO channel and watch Unpacking the Amicus to get all 3 pieces. The case, these responses were due by Monday the 5th. I think they're already all posted, and the case will be moving forward. It looks like there should be some answers coming through the end of December and possibly into the beginning of January, but who knows? Maybe we'll have a Merry Christmas.
It's going to be a wild ride in December. Stay tuned.
Yeah, stay tuned, and make sure you are subscribed to the VeriDAO channel and following us on Twitter as well. Take care.